Good afternoon, everyone, and welcome to today's webinar, Families First Coronavirus Response Act, What You Need to Know. I'm Yonina Shineweather, and I'm CPA and the Consulting Director of Compliance at Viventium. And joining me today is my colleague, Malka Trump, CPA, CPP, the Director of Compliance at Viventium. And together we're going to dialogue about this latest development, the new, what they call phase 2 relief in the face of COVID-19, what it means to employers, what it means to your payroll tax liabilities, what it means in terms of your Department of Labor obligations to your employees, how do you digest all of this, and how do you respond to this Response Act? Now, before we get started, just a couple of administrative points. First of all, I want to mention that today's webinar is being recorded. I know there have been some inquiry if it will be recorded and will be available for future reference. So the answer is yes, it will. Second of all, for those of you who have done webinars with us before, you know that I always say, if you have any questions as you go along, please don't be shy. On your toolbar, you'll see a question option. You can click on it and enter your questions, and I do see them throughout the presentation as well as Malka, and we try to work our answers into the presentation, and please do go ahead and use it, because like I say, if there's something that you're not sure about or you feel is not fully explained or you want a little bit of further clarification, then probably other people who have been listening have the same question, and you'll really be doing everybody a favor by expressing it and bringing it to the light. Time permitting, we are going to have a question and answer period at the end. So even if I don't get to your question during the presentation, don't despair. We're going to try to address them as we go along and at the end as well. Now, I would like to say, kind of by, I might say even on a personal note, this act is called the Families First Response Act. And I really take that very personally. And, you know, I feel that the IRS, Department of Labor, Congress, everyone's really extending themselves as much as possible in order to really put our priorities where they need to be. I think the overall message that's coming through with this legislation is that we are trying to put people first and families first. And so on that personal note, I just want to wish all of you to be healthy and well, you and all your loved ones, and that you're all weathering this very turbulent, this very remarkable time in as best a way as possible. We're living in a swiftly tilting planet, you might say, and it's not just the legislation and the developments from Congress and from the IRS and from Department of Labor that are pouring in, you know, one development after another, but it's of course just everything that's happening in all of our lives. And so I just, you know, want to really wish everyone the best throughout that. Speaking of putting people first, the IRS, in addition to the Families First Act, which is what we're discussing today, the IRS just issued further guidance called People First guidance. And that's of particular interest to anyone who has an outstanding liability to the IRS, perhaps an unresolved issue, perhaps an offer in compromise or an installment payment plan. What the IRS has said is that they're going to show extreme leniency in terms of any types of installment plans or payments that individuals or businesses cannot make. They will not be putting anybody into their automatic collection system. So if they had even an ACA penalty that was outstanding, one of those employer shared responsibility penalties, and you were dialoguing with them back and forth and it was going through collections, it won't go into the levy or to the lien stage. You know how the IRS has this automatic system after a certain number of days? Well, it's not going to be happening throughout this entire period, at least until July 15th. The IRS has said from April 1st to July 15th, they are putting people first before collections. And so that's comforting to know. And even though we're not focusing on that today, I just wanted to mention that it's out there. And also, I just wanted to make another resource available. If you wanted to learn more about what you could do to help your company, to help your workforce, I want to refer you to a recent article that we published called COVID-19, Preparing Your Biggest Assets and Business. That's a blog that contains some interesting insight and information that you can find on our Viventium blog pages. And in addition, as a bonus to today's webinar, everyone who's attending will receive as a follow-up a frequently asked question document about this legislation, about the Families First Act. Sometimes it's called FFCRA, or we're beginning to call it FCRA, I suppose. But whatever you call it, you'll be getting a FAQ about that in your email, and you'll be able to use those frequently asked questions in guiding yourself through navigating this legislation. So with that said, let's begin. And FCRA, which is also numbered Public Law 116-127, actually started out as HR 6201. Some of you may have been following it when it was HR 6201. It was passed first by the House of Representatives, then they amended it to make it a little bit easier for it to pass through Senate. Again, there's been a lot of bipartisan cooperation over this phase 2 relief. And then it was passed by the Senate during the day, March 18th, and then it was signed same day, later in the evening, by President Trump. So that was last Wednesday. It was signed into law. Now the question is, what is it? So there's a link here, and these slides will be made available to you. So if you wanted to go and click on the link, you would find yourself over here looking at the 116th Congress Act of the Families First Coronavirus Response Act. Now, it's actually a multi-part law with divisions A through H, but there are 3 divisions of this law that are interesting, that are relevant to us in payroll. Division C, which is called Emergency Family and Medical Leave Expansion Act. Division E, which is the Emergency Paid Sick Leave Act. And Division G, which is the tax credit for paid sick and family and medical leave. And those 3 divisions of the law are what we're going to be taking a look at. And I try to make this as hands-on as possible. So we're going to be giving examples. I like to jump back and forth into the law, into the PowerPoint slides, just so that, you know, we're doing this as candidly and as up close as possible, so that you get information that you can actually use and find useful and helpful. So let's take a look. The Families First Coronavirus Response Act, otherwise known as the FCRA, requires certain employers. So that's going to be our first question. Well, which employers? Are you covered or are you not covered? But those employers who are covered must be providing their employees with 2 things: with paid sick leave and with expanded FMLA, family and medical leave, for specified reasons that are related to COVID-19. Not all COVID-19 related reasons are cause for paid sick or expanded FMLA, only certain ones. We're going to talk about them. And the law is being administered and enforced by Department of Labor. They're in charge, and the law is going to go into effect on April 1st. Department of Labor came out and told us that yesterday. It's going to be in effect April 1st. Congress just said that any time within the first 15 days, it has to be effective. That would have given them until April 2nd. And the IRS said they were ready immediately to give tax credits. We thought it might even be during March, but yesterday Department of Labor said no. The effective date of this law is April 1st, meaning they're starting it with the second quarter. Any of you who have already gone ahead and started to pay this leave, that's certainly, I'm sure, appreciated by your employees, but it will not count toward the number of days, number of hours, amount of time that you need to give under this law, nor will it be available for a tax credit, which we're going to talk about as part of Division G. I know that's somewhat disappointing for those of you who actually went out already and, you know, put yourselves out on the line and laid out money and paid this. But unfortunately, this is what Department of Labor has said. We had kind of thought that since it's the end of March, the IRS might even scramble and put together a special 941, but they're not going to have to do that because Department of Labor said no, the law is not going to take effect till April 1st. So that was a surprise. But again, that is the situation, and that is, since Department of Labor were given the mandate to administer the law, they have the ability to say when it's going to go into effect. Now, I want you to note two things about this law, and it's not only families first, but it is a federal first. This is the first time that the federal government has ever mandated paid sick pay. We have states mandating it. We may have some municipalities. We have union contracts, various, but this is the first time that on the national level, there is going to be at least some degree of paid sick leave. Not unlimited, but some degree. It's also the first time that FMLA is being paid. When your employees go out on their 12 weeks of leave, right, it's unpaid leave. You have to guarantee them certain job protections, etc., but you don't have to pay them. But this is now, and the word is expanded family and medical leave, which means that it is going to be, at least part of it is going to be paid. Employees will get 12 weeks altogether, and 10 weeks are going to be paid, not at their full salary, as we'll see, but at least at some portion of their salary. So these are two firsts that the IRS has never done, the Congress has never done. We've never seen this in legislation before. Will it be a precedent for the future, for post-COVID America? It remains to be seen. That's one of the unanswered questions. There are 6 questions, though, as you saw in the description when you joined the webinar. You have an invitation. There are 6 questions that we are going to answer. And I want to start with our first question, but before I do that, I just want to put in a little disclaimer, and that is that neither I nor Viventium is engaged in the business of providing legal advice. I'm not an attorney, and Viventium is not a law firm, and therefore we are providing general consulting information based on published law and guidance. But before you implement anything, before you change your policy or make any decisions at all, please be sure to consult with your legal counsel, your tax advisor, your CPA, legally, to verify and to confirm what you should be doing. Second caveat here is that we are living in turbulent waters, in a rapidly changing environment. Guidance is being issued right and left, both by DOL and by IRS. Rules are flying back and forth. So the information that I am presenting today is effective today, effective March 26th. I cannot guarantee that it will be accurate tomorrow or next week, but what you're getting now is active, effective, up-to-the-minute information. So just keep that in mind. So the first question is, who is covered under this law? Who is the law addressing? So if you take a look at the legislation, it says employers of less than 500 employees are covered. So kind of surprising, like, where's that coming from? Basically, the reasoning behind Congress's, the intention behind Congress's wording is that, not that we don't want to benefit people who work for large companies, but that once a company has 500 employees or more, we assume that they already have at least equivalent PTO, paid time off policies in place, and that their employees are already getting the benefit of paid leave that they're willing to offer. And so we don't need to protect them under the law. That was basically Congress's intention. How do you count your 500 employees? Well, 500, you're already exempt. How do you count your 499 employees? So first of all, the Department of Labor has just issued guidance, and they've said it includes full-timers, it includes part-time employees, it includes temporary employees, but it does not include independent contractors who receive a Form 1099. Now, anybody who's familiar with the IRS or Department of Labor is probably asking themselves, well, 500 employees when? In total for the year, last year, look-back period, measurement period, kind of echoes of ACA. So the Department of Labor has taken an entirely different approach. They've said we're going to take a snapshot approach. On the day that the employee takes their leave, how many full-timers, part-timers, and temps do you have? Oh, by the way, don't count your offshore workers. So if you have somebody working in India or in any other country, you cannot count them to get yourself up to the 500 and get exempt. We're not counting offshore workers, citizens or non-citizens. They just don't count. So the Department of Labor says, take a look. On the day that the employee goes out on leave, count up your employees, and according to that count, you either are covered or not covered. It's kind of a fascinating approach because, look, for those of you who have 50 employees, 80 employees, 600 employees, and you're listening anyway, well, obviously you're not affected by this. But what happens if you have like a fluctuating workforce and you're somewhere around 480, 490, sometimes up to 510, sometimes 520? What if you're right on 485, 495, and you don't want to actually be covered under this law? Can you quickly hire some people? So Department of Labor has given us this fascinating snapshot approach, which means that if employee John Doe takes leave on April 2nd, and on April 2nd I have 495 people working for me on that day, I have to cover him for the full 10 weeks, the full 12 weeks, whatever the case may be. And if Jane Doe takes leave on April 3rd, but by then I've hired another 6 people and I'm now over 500, then Jane Doe's not covered at all. Or at least I'm not covered vis-a-vis Jane Doe. At least that is the way Department of Labor has worded its guidance. Will they issue clarification tomorrow or the next day? Perhaps. But at this point, the snapshot approach is telling us that in order for an employer to know whether they must pay an employee paid leave, they have to look at their number of employees at the time the leave starts. So that's number one. That's who's covered under the law. Who's exempt? So Congress wrote that employers of less than 50 employees whose viability will be jeopardized if they follow this law are exempt from the child care portion of the law. As we're going to see in a few minutes, there are various reasons that you can take leave. One of them is to care for a child whose school has been closed, or whose place of care has been closed, or whose care provider is not available due to COVID-19. And those employees who can't work and can't telework. If you can telework, you don't qualify. But you're so busy caring for this child, you can't work and you can't telework. You, in theory, can collect leave under this law. But if your employer is less than 50 employees and their business viability will be jeopardized, then they don't have to pay you the leave. So again, if you're an employer of 49 employees, you may fall into this if your viability will be jeopardized. Now, what does it mean viability will be jeopardized? The guidance about what that means is still to be issued by Department of Labor. See what I mean? Like, we still don't have complete information at all, but at least we know that guidance is on its way. What the DOL has said is that if you want to elect the exemption, document the reasons, document how you meet the criteria, and don't send anything to us. Don't apply for an exemption. Don't write us letters. Certainly don't call us. Just keep your documentation. And that's all you have to do, and then you don't have to pay this leave. So we're still waiting to hear what the criteria will be, but once those are issued, which could be today or tomorrow, then just document it for yourself, work together with your legal team, to make sure your documentation is sufficient, and consider yourselves exempt. Now, a question was asked about this snapshot approach for the exemption. Is the snapshot approach still appropriate to the 50 employees or less? It's really an excellent question. In other words, at what point do we say that the employee has 50 or less? Is it on each day that the employee leaves? So sometimes you are exempt and sometimes you aren't. Well, we don't know yet. Unfortunately, we don't have the answer to that question. That's going to be hopefully addressed by the guidance that will be issued by the Department of Labor. Now, I've gotten a few questions about temporary layoffs and obligations if you don't have enough work, enough hours for your employees, and therefore they're temporarily laid off. Are they then covered under this law? And this is a very important distinction to make. If you have work for your employee and your employee can't work for one of the qualifying reasons that we're going to discuss, then they qualify for this paid leave. The work is there, but they can't do it. And they can't even do it from home. They can't even telework. That's when they qualify. That's when this law, the FFCRA, kicks in. If you don't have work for them, whether you're doing rotating to encourage social distancing and therefore they're working 33 hours instead of 40 hours, if you are temporarily laying them off because your place of business must be closed and the nature of the business is not such that they can telework, if for whatever reason there is no work for them to do, then they are not covered. Then they fall into a category of unemployment, perhaps, or partial unemployment, as the case may be. And they would not be covered under paid leave. Again, so this law is only when it's coming from the side of the employee. There's work for them to do, even from home, but they can't do it. That's when this law takes effect. Very important distinction. And again, I know some of you are saying, well, wasn't the law effective immediately? No, unfortunately, the law was not effective immediately. The IRS issued guidance a couple days ago saying that the tax credits are available immediately. That was where the word immediate was used. But we have to put on our legal caps here, think a little bit like lawyers. The tax credits were available immediately on wages that are paid under this law. But we can't yet pay wages under this law because the Department of Labor has said the law goes into effect only on April 1st. And in their guidance, they specifically said the law is not retroactive. So that means that anything that is paid until April 1st is not eligible for tax credits that we saw in Division G. We're going to discuss those tax credits in depth, nor is it even counted toward your required paid leave. And we're going to talk how many hours, how many weeks do you have to pay, whatever those numbers are, 80 hours, 12 weeks, but the clock is not ticking. Any leave that you've granted is not included. Now you might say, well, but we relied in good faith on Congress. Again, here's where I tell you I'm wearing my CPA cap and not my lawyer cap, because I don't have a lawyer cap. This is something you would have to turn to legal counsel and say, well, do we have any recourse? We've already paid under this law, which we assumed was taking effect. Is there any type of relief that we can be granted to actually get credit for this or get this counted toward our time? That would really be a question to refer to a labor attorney. One of the other questions that was discussed, or that was billed in the description of this webinar, is how is this type of family and medical leave different from the standard, the regular, what we're used to? So first of all, we know that it's paid. At least 10 weeks of it is paid, whereas regular FMLA is not. But there's another provision in the law that's very surprising. Well, I shouldn't say very surprising, that's in line with our theme of putting families first, and that is, any employee who worked for the past 30 days for your company, meaning they were on payroll no matter how many hours, they were on payroll for 30 days. Once they've been on payroll for 30 days and this FMLA applies to them, they're eligible. Regular standard, the vanilla kind of unpaid FMLA requires at least 1,250 hours of employment, and that requirement does not apply here. So if you have somebody on payroll for 30 days, anytime between now and December 31st, and then they have a child whose school is closed or, care provider is not available and therefore they can't work, you're obligated to pay them 10 weeks of paid family medical leave coverage, which is also called child care pay. That's what the IRS has been calling it. So now let's take an example of someone who's been working for a company as a temp, and then the company hires them on a full-time basis. They go temp to perm. Any days that we worked on a temp count toward those 30 days. So this is something you want to keep in mind, especially those of you who use temporary employees, temp to perms, that if you do take them on as a permanent employee, the 30-day clock started to work from the time you began to use them as a temp. Okay, so now some of you have said, well, what's the law? Can you please describe the law already? So fine, let's talk about it. Remember I said there was Division C, Division F, and Division G. Let's start with Division C of the FCRA. Division C discusses paid child care leave. This is also called extended family and medical leave. They are synonymous. It's a little confusing right now because everything's happening so fast. Congress used one term, the IRS is using another term, DOL is using a different term. So you just have to get used to the synonyms. Emergency paid family leave, that's what it's called by Congress, or expanded family and medical leave, another term Congress uses. The IRS is calling it child care leave, That's what the IRS has dubbed it. A Department of Labor is referring to it as FMLA. So all of these things are talking about Division C of the law. And what is it? It says that if you cannot work and if you cannot telework because you are taking care of a child whose school is closed, whose care center is closed, or whose provider is not available, then you can take 12 weeks of family and medical leave. And this is in addition to your regular FMLA. The first 10 days of this paid childcare leave is unpaid. You can use your own paid time off if you have coming to you. The paid sick leave that we're going to discuss in a couple slides from now can be used, but it's not paid under Division C of FCRA. It's not paid childcare leave. Your employer doesn't have to pay you for those 10 days. The next 10 weeks, as long as you need to be out, as long as you take it, and they don't have to be contiguous, you know, if you had one child and you need to go out for another child, God forbid. But yeah, the next 10 weeks are paid, not at your full pay, but they're paid at 2/3 of your, quote, regular pay. And as you know, whenever Congress says a term like regular pay, it's going to be defined. So we'll define it soon, but it's paid at 2/3 of your regular pay, up to a limit of $200 a day, and also up to a limit of $10,000 for the entire 10-week period. That's what Division C says. By the way, who has to pay for this? Well, you, the employer, think maybe I have to pay for it as the employer. So the answer is yes and no. You, the employer, has to pay for it, but we'll soon see the IRS is going to make good to you on it. The IRS is going to make sure that you get that money back. They claim within 2 weeks. We shall see. We're going to talk about that when we get up to the tax credit portion of the webinar. So, you know, who's going to foot the bill in a minute? What's the definition of regular pay? We're going to talk about that. What age child? They're saying a minor child under age 18. Okay, so as the question was asked, is a 13-year-old child eligible? Yes, any minor child under age 18 qualifies the employee to take paid child care leave for them. Let's move on to the next division, Division F of the law, and that's paid sick leave, which is kind of like a tandem, hand in hand with the paid child care leave. Paid sick leave says that there are 6 reasons that you can take paid sick leave, all COVID-19 related. And for those 6 reasons, you can take 80 hours of leave, up to 80 hours of leave, which is another way of saying 10 days or 2 weeks. And how much leave the employer has to pay you, or you, the employer, has to pay your employee, depends on which one of the reasons the employee is taking the leave for. So 1 and 2 are self-quarantine, whether it is, reason number 1 is a quarantine that a government agency has imposed, a legal quarantine. Number 2 is a quarantine that your medical provider has suggested, has recommended that you do. And number 3 is if you yourself are experiencing, God forbid, any symptoms of coronavirus and are seeking medical care or a diagnosis. Those are the 3 reasons. We call those self-care. And if you are taking leave for self-care, you get your full regular pay. And again, we will define what regular pay is. Don't worry, Congress doesn't do anything without having some guidance follow up what the definition is. But you will get your full regular pay up to a limit of, quite generous, $511 a day, much higher than the family and medical that we just saw, the child care. And a total for those 80 hours of $5,110. Reason 4 is if you are taking care of another individual who is quarantined, whether it's a government-imposed quarantine or a medically recommended quarantine. Reason 5 is if you are taking care of a child whose school has closed or whose place of care has closed or is not available, similar to what we just saw for the continuing family leave. but this is only for the first 2 weeks now. And reason number 6 is any substantially equivalent reason that Department of Health and Human Services deems, in future guidance. Again, future guidance. So if you are in any of those other 3 reasons, taking care of another individual quarantined, taking care of a child whose school is closed, or something substantially equivalent, you get only 2/3 of your regular pay. You get up to $200 a day and a $2,000 total for the 10 days. So if we look back for a moment, and I'm going to backtrack with you to our previous slide, the paid childcare leave, notice how the first 10 days are unpaid? But it says there on the slide, and that's what I was referring to, paid sick can cover it. So let's jump ahead again. You can take, for those first 2 weeks, for those first 80 hours, you can take this paid sick leave if you're caring for a child whose school is closed. And that's a $2,000 total. And then for the remaining 10 weeks, you can get up to a $10,000 total. And that's why we'll see on the required poster that Department of Labor is going to have you hang up or email out. We're going to see that they state the total for this reason is $12,000 because they're counting the $2,000 for the first 2 weeks and the $10,000 for the remaining 10 weeks. Now, some people have asked, well, what if both reasons exist? Let's say an employee of mine gets quarantined and they take, their 80 hours, and then later in the year, their child's school closes or the child gets quarantined or someone in their family gets quarantined and they have to stay home to take care of them and they're not available to work. Can they get this 80 hours for the second reason? So that was a question that we had. Congress did not clarify that, but Department of Labor did yesterday, and they said no. Both reasons together may not exceed 80 hours. You get 80 hours between April 1st and December 31st, and that's it for whatever the reason is. Okay, now the limits will be different. And of course, whoever is paying their employees needs to have a way of tracking. They have to have a system that helps them track how much is self-care and how much is other care, because the limits are going to be different, and therefore the tax credits are going to be different. And again, someone asked, are these first 10 days only starting April 1st? And I must stress this and reiterate, yes, the law only goes into effect April 1st. So if your employees took any of these days, if you paid any hours of paid sick leave before April 1st, it does not count. You have to give them a full 80 hours starting April 1st. Now, some of you have been asking, what is regular pay? You tell me, if it's self-care, you get 100% of your regular pay. If it's childcare or other care, it's 2/3 of your regular pay. What's the definition of regular pay? So the Department of Labor came along and defined it for us, together with the IRS. And they said regular pay is, not surprisingly, regular hours times your regular rate. So now let's define regular hours. Let's define regular rate. And they do. Regular hours, well, if you're a full-timer working a fixed number of hours, those are your regular hours. If you're a part-timer or if you're a full-timer with a varying schedule, then we have to take this employee's average hours over the past 2 weeks. Take 2 weeks, what are their average hours? That's called the regular hours. What if we don't have average hours over the 2 weeks, or not even the past 2 weeks, any 2 weeks? What if their hours are always varying? There's no fixed amount, it fluctuates wildly if it's not available. So fine, they've said you can use the 6-month average. Go back 6 months, take an average over 6 months. What if the employee hasn't been working for you 6 months, or the state is not available for whatever reason? Then what? So the guidance says, okay, if that's not available, use whatever hours you've agreed upon. When you hired this employee, you must have had some agreement about how many hours they're expected to work. Use that. And what if you don't? What if you didn't have any agreement? You just hired them without an agreement. So the last option that we fall back upon, the guidance says, is use their average daily scheduled hours. Most companies have scheduled hours for their employees, so just use whatever is scheduled for them daily, and that's called the regular hours for a particular day. What about if someone is scheduled for overtime? So do you have to count those hours? The answer is yeah. Scheduled overtime also counts as, in this case, regular hours. It's kind of ironic, right? We're talking about overtime as regular hours, but that's what Department of Labor has said, and they're a Department of Labor, so they know what they're talking about. Scheduled hours of overtime count, but you still only have to pay them up to 80 hours. You never have to pay more than 80 hours of paid sick leave. So take an example. Let's say, and this is a Department of Labor example actually, so you know it's official. Let's say an employee is scheduled to work 50 hours a week. They're scheduled 10 hours of overtime every week. That means they can take 50 hours of paid sick leave in their first week, but then they only get to take 30 hours in the second week. In other words, in any event, the total number of hours is always going to be capped at 80. So that's regular hours. That's the first step in our equation of regular pay. What's their regular rate? Well, I give you a little link here, and this is the link to the Department of Labor's definition of regular rate, which you're familiar with. But what we're looking at now is their average regular rate over the 6 months prior to their leave. You have to go back, add them up for a pay period, divide, and that will be the regular rate. What if they haven't worked 6 months? What if the data is not available, although it should be if you're keeping the records that you're supposed to be keeping? But for whatever reason, if you can't do that, so the Department of Labor has said, use the average regular rate for each week worked. Just, take the week's worked, take the average regular rate, and that's what you're going to be using. It's an average anyway. And another option they're giving you is just add up all the compensation over the period, add up anything that went into regular rate for hours worked, and then divide by all hours actually worked. So for compensation for hours not worked, whether it's paid sick, paid vacation, paid holiday, that doesn't get added into this. It's just the compensation that would normally be added into the regular rate, just like the way you do when you figure out overtime rates, right? You have to figure out your regular rate and divide by all the hours actually worked. That's your regular rate. Take that, multiply it by what we said earlier is the regular hours, and that will give you regular pay, and then pay 100% of it. Employees are going out on self-care for 80 hours, or 2/3 of it to employees who are going out for other care. And in addition, that's also 2/3 of it for the remaining 10 weeks of their childcare leave, of their FMLA leave. Anything that's normally added into regular rate gets added into this regular rate. It's the basic Department of Labor definition of regular rate. So this is what you have to pay as an employer. You have to pay two things. You have to pay 80 hours of paid sick, and you have to pay 10 weeks of childcare leave. But you don't really have to pay for it, because comes Division G of the law, and they say, we're going to give you lots of different kinds of tax exemptions and credits to make this work for you. Not only are we putting families first, but we want this to really work for employers. We want to foot the bill. That's basically what they're saying. So the first thing Congress said was that paid leave is exempt from employer Social Security. In other words, what you pay out for those 80 hours, up to that, $2,000 or up to that $5,110 per employee, or what you pay out for the expanded family medical leave, the child care, up to $10,000, all of that you don't have to pay Social Security on. And Congress worded it a little bit circular. They said you pay Medicare, but the Medicare is a credit against your employer Social Security. Department of Labor, IRS short-circuited that, and they just said all this paid leave is not going to be subject to employer taxes. Employers don't have to pay any taxes on paid leave. Now, we don't know what the IRS means by that, meaning we don't know if it's going to be exempt from FUTA. They said payroll tax. They didn't say anything about unemployment tax. And one of the things Malka is going to be discussing in the later part of the webinar is open questions that we have reached out to the IRS about, that we are waiting for further guidance. But one thing the IRS has said clearly, and that is that this paid leave is going to be exempt from employer payroll taxes. Okay. What else? What other credits are they offering? They're saying that any paid leave that you as an employer pay is going to become an immediate tax credit for the same payroll against your federal tax liability. Meaning when you have to make a deposit for federal withholding tax from your employees, from employee share of FICA, from employer's share of FICA, your 941 deposit, any amount, and we're going to see an example soon, but any amount that you paid as paid sick leave or paid childcare leave will reduce the amount of tax that you have to deposit to the IRS. You just put that money into your pocket as a subsidy, as a repayment of the paid leave. And this, is very surprising because, one of the most sensitive things that the IRS has is what they call the fiduciary taxes, or what the employers collect. They call them trust fund taxes, because when you withhold money from your employees, you're holding that money in trust. It's the IRS's money, and you better pay it over to them. Otherwise, they come after you with 100% penalty. They can pierce the corporate curtain and hold you personally liable for those taxes. And so for the IRS to go ahead and say, just take all that money that you withheld from your employees and keep it for yourselves, because we're paying for this leave. You don't have to pay for it. We're going to pay for this leave. There's some problems with what the IRS has said, because, and Malcolm will discuss this a little bit later, I don't want to complicate things right now, because Congress really only gave a mandate for the paid leave to be offset against employer Social Security, but we'll discuss that in a little while. But right now, the IRS guidance, and until it's retracted, that's the guidance. The IRS guidance is that as soon as you pay leave in the same payroll, you just deduct whatever you paid from your federal deposit, and then you're reimbursed that way. Now, of course, you may be thinking to yourselves, well, what if the amount that I pay in paid leave is higher than my federal deposit? Then what? So the IRS said, we are going to issue a new form. It's going to be a streamlined claim form that you're going to fill out each payroll and submit to us at the IRS, saying how much more you paid out in paid leave over and above the amount of your federal tax deposit, and we'll refund it to you within, and get this, 2 weeks. This is what the IRS is saying. It will be a refundable credit. You'll get that money back. So we're not asking employers to lay out money for any longer than 2 weeks. Now, remember, if you have 49 less employees and you still feel those 2 weeks are going to jeopardize your business, you may be exempt if you just follow the guidance, which DOL will issue. It's not been issued yet, as we said. But most employers who are actually complying with this law are going to be able, and it really is surprising, are going to be able to offset that against their federal tax deposit each week. There's one more credit that the Congress is making available, and it's also going to go through the IRS, and that is healthcare costs for any employees who go out on sick leave will also be a credit against the employer's federal tax deposit. So that means if you have an employee who's going on sick leave and you're paying money to keep their insurance, you're paying premiums for their insurance premiums, any amount that you pay for their insurance premiums, you can also use to reduce your payroll. So now that, if you do, usually you pay premiums once a month. If you put that against your federal tax liability once a month, you may max out of your federal tax liability and then have to wait for your refund. So you're probably going to be allowed to do it prospectively, payroll by payroll, like prorate your monthly expense over each payroll. Again, we're awaiting further guidance from the IRS about this. We're awaiting the claim form. We have to see exactly how the process is going to work. But the principle of the matter is that any premiums that you pay to continue insurance for employees on sick leave, not on, doesn't say it regarding the child care leave, the extended 10 weeks, but those 80 hours of sick leave, that's also a credit against your federal deposit. So let's take an example. And this is not my example. This is the IRS's example. I wouldn't have believed it if I hadn't read it from the IRS. If an employer paid $5,000 in sick leave and you're otherwise required to deposit $8,000 in payroll taxes, not necessarily from the same employees. Note that. The IRS says, including taxes withheld from all its employees, even those not out on sick leave, then you as the employer can use up to $5,000 of that $8,000 of taxes that you were going to deposit for making these qualified leave payments, both the sick and the child care. And therefore, you as the employer will only be required to pay the remaining $3,000 on your next regular deposit date. And the second example, if you, as an eligible employer, pay $10,000 in sick leave. Now remember, these amounts that you're paying are subject to all those limits, meaning you can't count more than $200 for an employee a day for childcare, or $511 a day for self-care. You can't count more than $10,000 for the 10-week period, or $5,110 for the 80 hours of self-care, or the $2,000 for the 80 hours of childcare. It's subject to the same limits. But if you pay $10,000 in sick leave in a payroll, and you only had an $8,000 payroll tax liability for that payroll, you could use the entire, you could just forget about that $8,000. You know, that's yours to keep because you paid that already in leave. And for the remaining $2,000, you can file a request for what the IRS calls an accelerated credit and get it back within 2 weeks, is what the IRS is promising. Those are the IRS examples. There's one more piece of information that Department of Labor has released in its guidance yesterday, and that is that Congress had mandated them to issue notification requirements, and they did, and they said that there is now a poster available. Here you have a little thumbnail of it, and this has to be posted in a prominent place in the employer's location of work in order that employees are aware of their rights. However, since so many employees are not coming into work and are not going to see anything posted anywhere in the work site, you can fulfill your notification requirement by either emailing it to your employees, downloaded from the site, and I gave you a link. If you just click over here on this link where it says email or snail mail, click on it, it'll take you to the site where you can find posters. You can either email it as a PDF to your employees, you can snail mail it to them, print it out, or you can post it on a company internal or external website. And by so doing, you have fulfilled your notification requirement. Also, new hires must be given this notification detailing their leaves. And I just want to point out to you, I think I mentioned this earlier, but if you look at these bullet points here, a bit small, but it mentions that if you're going out for FMLA, for the expanded child care credit, the child care leave, I should say, you get a maximum of $12,000 of leave. And you might say to yourself, well, where is that $12,000 coming from? I was just in a webinar with Yonina Scheinweather, and she said the FMLA expanded emergency child care, whatever you want to call it, is $10,000. So you have to realize what they're doing here. If you read it carefully, they're lumping together the $2,000 for the first 10 days of childcare, and then the remaining $10,000. They just worded it a little bit differently, but if you read it through, it's basically saying the same thing. And they also have a little caveat down at the bottom about enforcement. Department of Labor says we will not enforce this law for the first 30 days. So even though the law goes into effect on April 1st, enforcement will only start 30 days later. Of course, we're all trying to do best by our employees and get them funds that they need as soon as possible. The DOL is just saying we're not going to be draconian about this. We're going to give you the space you need to actually implement it. So that is the poster and the notification requirement. And now I want to invite Malka to discuss with you what we don't know. Up until now, we've been talking about what we do know about the law. And increasingly, as we study it, we realize how many more questions we have and guidance that needs to be issued. So Malka will discuss that with you.
Okay, thank you, Yonina. So as you can see, there has been a lot of information coming out quite rapidly over the past week, and a lot of guidance. And even with all this information, there are still a lot of open questions that we are waiting further clarity from either the IRS or the Department of Labor. So I just wanted to go through some of those open questions. So the first one we have here is the IRS overstepping its congressional mandate by allowing a credit against federal withholding and employee FICA as well? So Yonina touched on this earlier. But under the law that was passed by Congress, employers can take a tax credit for the paid leave that they're paying out to offset the employer portion of Social Security. When the IRS came out with its guidelines, they said that the employer can take that tax credit to offset also federal withholding and employee FICA. So are they allowed to do that? Will that be upheld? Will it be opposed? That remains to be seen. Okay, so moving on. Are sick and child care payments subject to federal withholding, FUTA, and employee FICA? So as we mentioned earlier, the sick and child care payments are not going to be subject to the employer portion of Social Security and Medicare, so employers are off the hook for those taxes for all these payments that they're making to their employees who are out on leave. However, the guidance is silent on whether the other payroll taxes apply to these payments or whether they're exempt, specifically federal withholding, federal unemployment, and the employee portions of Social Security and Medicare. So again, another open item. Okay, moving on to the next question. And Yonina touched on this as well. The law seems to be written that the health plan expenses credit is only available for sick leave. So under the paid sick leave portion of the law, it says that employers can also get a tax credit for the health cost expenses that they're paying for that employee who's out on leave. But the law is silent about whether that applies to the FMLA leave, the child care leave, which is an additional 10 weeks to take care of a child whose school has closed or their care facility has closed. The law is silent on that. So the question is, does that health plan expense credit apply also for the 10 weeks of child care leave, or does it only apply to paid sick leave? Next, is the healthcare cost credit available for the first 2 weeks of unpaid child care leave if the employee does not use their paid sick leave for this time? So this is kind of related to the question we just discussed. So in the case that this healthcare credit is available for employers for the child care leave, for that expanded FMLA leave, so if that is the situation, the question is, for those first 2 weeks, those 10 days, which are first unpaid leave before the 10 weeks of paid leave kicks in, does the healthcare credit apply during that time? Obviously, the paid leave credits would not be applicable at that time because there's no leave being paid out at that time, so the employer couldn't take any credit. But would the employer be eligible to take that credit for healthcare costs? And next, if an employer gives more than the mandated leave, is the health plan expenses credit still available? So as we just had seen earlier, the paid sick leave is maxed out at 80 hours. So once an employee reaches that 80 hours, the employer is no longer required under this federal law to pay them out for this emergency paid sick leave. Now, an employer can choose to keep paying the employee. Maybe they'll pay them for 3 weeks instead of 2 weeks, which is fine. Obviously, the employer can do that. The employer would not be eligible for tax credits for those paid leave payments during that extra week. However, would they still be eligible for health plan expenses credit? We don't have clarity on that. The law very clearly says the tax credits for the paid sick leave is for those 2 weeks only, but the health plan expense credit still unclear. And of course, we're going to be looking out for a new Form 941 for second quarter. First quarter, we seem to be okay since the law doesn't go into effect until April 1st. The first quarter Form 941 is not expected to change. But the second quarter form, we are expecting there to be some sort of reconciliation where the IRS can reconcile what the employer paid out in paid leave and what they got back as tax credits. So, of course, that should be forthcoming in the coming weeks or months, and we'll be able to see what that form looks like. And lastly, what will the state treatment of these payments be under the Family First Act? So until this point, states have generally been silent on whether these paid leave payments, which are required under federal law, on whether they'll be taxable under state law or whether states will say that they are exempt and employees don't have to pay state taxes on them. Maybe as we approach April 1st, the effective date states will release more guidance on the taxability of these payments. But right now, we don't have information on that. One thing important to note is that whether or not there is state tax or whatever taxes are applicable to these payments, employers are entitled under federal law to take a tax credit for the full gross amount of the paid leave that they're paying their employees. So even though an employee is not going to get that full gross amount in their bank account because there's going to be different taxes withheld from the paycheck, the employer can still take the tax credit for the full gross amount. So again, a lot of things still open. Of course, we are constantly monitoring developments and sending out updates as information comes in. So I'm sure many of you have further questions on this. So in the minutes we have left, I am going to send this back to you, Yonina, so you can answer some questions from our attendees.
Sure. Thanks so much, Malka. And yeah, there's just a lot of information that still needs to be collected, and not too much time for that guidance to come out before the law takes effect. How can you continue to monitor and see what's happening? So I've given you some resources over here. We want you to have these at your fingertips to be able to refer and update yourselves constantly. The U.S. Department of Labor site is the first one. You have them in little thumbnails down at the bottom. And that is where you have the notification, the posters, specifications about exemptions and who's going to be exempt. The IRS site, the IRS is not so much concerned with paying out the leave. They're more concerned with how employers are going to get that money back, meaning the tax credits and the tax credit process. So that's an important site to keep your eye on, especially since, as Malcolm mentioned, we have this unprecedented departure with the IRS, so greatly expanding the credit much more than what Congress had said, not just employer Social Security, but employee Social Security and federal tax as well. So we have to see if there will be any type of a pullback, any type of retraction from the IRS on that. The truth is, the more time that goes by and, the IRS has not retracted, it seems this is what it's going to be. But of course, till those forms come out, the claim form and the 941 for the second quarter, we're not going to be sure. So we have to keep our eye on that second link as well. And for those of you who are current clients today of Viventium, the Viventium CUC, the Coronavirus Update Center, contains a wealth of information, both from CDC, in terms of helping your workforce weather all of this, and it contains all of our email communications, and they've been copious over the past few days by necessity. And it just is, that's where you would go as the first go-to for the latest developments and latest information. It contains some treatment of this pay under workers' compensation, other types of aspects of what's going on with coronavirus relief. And of course, once phase 3 of the relief package is passed, the updates will be there as well, whether it will contain a payroll tax cut, whether it will contain reducing employee Social Security from 6.2% to 0%. These are all proposals, of course, that are just being discussed. They have not yet been implemented and not been passed into law, but if you check the site frequently, in addition to monitoring your inbox, you will have all that information. And now I just want to spend a minute or two answering some of the questions that have come in. A couple of you have asked about what type of proof do you as the employer have the right to expect from your employees? Let's say someone just goes out on leave and they, what can you ask them? How far can you ask? So basically, as soon as an employee comes to you and says, I want paid FFCRA leave, and as soon as you pay them 1 day of this paid sick leave, you have the right, and Congress had said that, and Department of Labor backed you up, you have the right to ask for reasonable notice of their health condition or the condition under which they're subject, if they're taking care of a child or another individual who's been quarantined. So you can't ask for it before you pay them. You have to pay them at least 1 day first. But once they make that request of you and you do pay them that 1 day, then you are entitled to ask for reasonable notice. Another question, if a daycare facility voluntarily closed, would that still qualify the employees to collect the child care leave from their employers? And the answer is yes. If the daycare facility is not available for any reason, whether it's an imposed closure or it was a voluntary closure, but it's not available due to the pandemic, Therefore, once that happens, the employee falls under this relief and would be able to collect the paid sick leave. And last question for now is, do the 80 hours or the 10 days have to be consecutive? In other words, in the option where someone has to care for a sick or quarantined individual, do the 10 days have to be consecutive, or would they qualify if the days are spread out? And the answer is they do not have to be consecutive. They can be spread out. And over the 3-quarter period from April 1st to December 31st, they cannot exceed 10 days or 80 hours. I want to let you know that we value your feedback on this webinar, and we look forward to sharing with you more insights to help you successfully navigate these very, very choppy waters of COVID-19 legislation. As I said, you'll be receiving a bonus in your email box, so look out for it, of our frequently asked questions, which summarizes a lot of information discussed and contains additional guidance. And on behalf of Malka and myself, I want to thank you all for your attending and for your interest and for your feedback during today's webinar. Thank you and have a great afternoon.